May I? Hello, in item 115, I appear for the DDA. May I be allowed to move an appearance slip as we were unable to do so before?
115?
Yes, my lords, for DDA.
You didn't even utter a word?
Because we were just...
What are the facts of the case?
Yes, my lords.
Yes. Yes, please.
Yeah. Clause item 116 is coming from a civil suit. I was the defendant. I'll just provide a very short background.
Okay, this is the last part. We won't take up any more. Yes.
I was the defendant in a suit instituted in the year 1978. Suit was decreed against. Suit was for declaration that a relinquishment deed in my favor is invalid and possession of the property which is subject matter of that relinquishment must be handed over to the plaintiff.
I hope I didn't deal with the suit in the High Court. Did I?
No.
I didn't deal with the suit in the High Court.
No.
Right. Yes. Yes, please.
So, suit was decreed against the defendant. The defendants filed an appeal. Several grounds were raised. 11 issues were framed by the trial court. All of them decided. The first appellate court holds against the plaintiff both on merits and on maintainability. The first appellate court holds that on maintainability, suit is time-bound. The first appellate court also holds that the suit is bad for non-joinder of the necessary party being the actual owner of the property who ought to have filed the suit. The first appellate court also says under section 115 of the Evidence Act, the successors of that owner are estopped by his actions because he executed the relinquishment deed. So on these grounds and also on merits, which is that there was a will, the construction of the will was an issue, the first appellate court holds in favor of the defendants. So the plaintiffs went up in appeal, second appeal before the Honorable High Court. Before the Honorable High Court, only one question was framed as a substantial question of law. That question was, is the judgment of the lower court unsustainable for being perverse? But it was a speaking order indicating the mind of the court and the contentions of the parties as to what apparently was an issue. For good or bad reason, there was nothing adverted to on the point of limitation or on the preliminary grounds of maintainability of the suit itself when the question was framed. Ultimately, the second appellate court reverses the first appellate court only on the merits of the case. Does not advert to issues of maintainability. So I rushed here by way of SLP. And the preliminary point I urged before my lords was that, look, I succeeded before the first appellate court both on maintainability and merits. The second appellate court, without adverting to the issues of maintainability, particularly that of limitation, has reversed the first appellate court only on merits. So the Honorable Court felt that since the court has not applied its mind, it's proper that I go and pursue my remedy by way of a review. So I went and filed a review with liberty to come back if the decision is adverse. Unfortunately, in review, the court says that you are at liberty to urge the issue of limitation, but you did not press it during the hearing. So, in a manner of speaking, sub silentio, the issue is taken care of because you did not press it. And holds, in any case, the issue of limitation does not even arise in the matter because your relinquishment deed is void. So that is how I came up in appeal. My lords, on the first day of listing, granted leave and ordered status quo. And in November, they were doing some changes in the property, so I moved application for early hearing along with directions. My Lord, the Chief Justice, the bench presided by my Lord, was kind enough to clarify that order and say that nothing will be done during the pendency of the appeal, and also listed the matter for final hearing. So that is how it has come up.
Okay, now tell us, what's the date of the relinquishment deed?
Yes.
And who had executed it?
Yes.
And how you related to the person that's
Yes. Would my lords kindly have page 86? There is a family tree. My lords may just make the notation of the dates against page 86, annexure P1. May I hand over a list of dates? I prepared a 2-page list of dates if it would assist my lords.
Page 86.
And
yes. Yes.
Lords, at page 86, there's a family tree.
Yes.
Now, Makhan Singh is the common ancestor. He died on 18/9/1971. 18/9/1971, he died. Now, prior to his death, 2 months prior to his death, he had executed a will. Now, to be fair, my lords, though we have disputed the authenticity of the will and whatnot, issues were framed because there are now 3 judgments. I'm not going to get into it. I am going to address the Honorable Court on the issues that I have just indicated at the outset. Because the validity of the will, etc., is something that the trial court and the first appellate court applied their minds to and held that substantially the will is valid, only one clause is invalid. So I will not get into the defendant's contentions about whether the will is
the date of the will?
Very good. So this 16th of July 1971.
Yes.
Lord, the relinquishment deed in my favor is on 29th.
Who are you?
I am Mankor. Now, my lords would see from the family tree, there are 2 branches. Mankor is on the extreme left, 1 step down. She is the daughter of Makhan Singh. On the right-hand side is Gurcharan Singh. The respondents before my lords are the legal heirs of Gurcharan Singh. I am the legal heir of Mankor. Therefore, Makhan Singh died, leaving behind a will, and I must state at the outset that the will left the properties of Makhan Singh only to the son, to the exclusion of the daughter. That's what the will says. The will also says, for a period of 10 years from my death, Gurcharan Singh, my son, shall not alienate the property, bequeath to him. That's what the will says. And the first appellate court says that this condition is void for various legal considerations. So, Mankor, my lords, was the daughter. The relinquishment deed was executed by Gurcharan Singh in favor of Mankor, the brother in favor of the sister, on 29th of June 1973.
29th of June
1973.
When did Gurcharan Singh die?
He died. Now that is a moot question. There is no proof of Gurcharan Singh. He was alive, admittedly, when the suit was instituted in 1978. The suit was instituted on 4/1/1978.
Suit was instituted on
4/1/1978. 4th of January 1978. Admittedly, Gurcharan Singh was alive and kicking on that date.
Was alive?
Yes. There's no dispute about it. Because so one of the preliminary objections we raised is when he is the person who apparently inherited, where's the question of his wife filing the suit in an anticipatory capacity that she would inherit the property if he is no more. So that was the objection we had raised. When the suit was pending, they filed an application for amendment of the plaint sometime in the year 1984 saying that he is missing, unknown, we don't know where he's gone, so please declare him to be dead, civil death, and consider that the matter is competent. 1985. 1/10/1985, the suit was amended with pleadings to the effect that he's gone missing. We don't know his whereabouts. So that amendment was allowed in the year 1/10/1985. The suit eventually, after framing of 11 issues, and what was the suit about? The suit said that under the will, the son was given sole ownership of the properties. Fraud was played on my husband because he was a man of unsound mind by his sister to execute this relinquishment when there was nothing to relinquish. She did not get anything. Where's the question of he relinquishing it? So she exercised undue influence on him, and being a man of unsound mind, he executed this registered relinquishment deed. The trial court holds, whilst agreeing with the fact that the reliefs have to be granted, that he was not of unsound mind or not laid any evidence. But fraud is made out. The trial court also says that the suit is within limitation because they discovered of the factum of this relinquishment deed only at the time that they filed the suit. So there's nothing wrong with their averment that the suit is within limitation. Because once fraud is pleaded under section 27 of the Limitation Act, it is from the date of discovery. So they have pleaded it, so there's no difficulty. So this happens, my lord. The suit was decreed on the 16th of July 2003. I must also place one other incidental fact. From the year 1975, when the relinquishment deed was executed, my clients were in the possession of the
You are in possession.
Yes. That is also undisputed, which is why the suit was for possession. Give me back. So the suit was decreed in the year 2003.
But it is partial possession. Half of the portion was in my possession, admittedly, as per the WS, and half was in their possession. Sorry to
Yes.
My learned friend is right. At page Q, I have made that statement saying that because we are all family members, we permitted them to stay at the back portion of the shop. It is a shop of about 900 square feet from what I understand. And by way of consent and because of familiar, but thereafter in 1978, because relations grew sour, they said that we want the whole of the property. So 16/7/2003, the suit was decreed. All findings against the defendant except for actually the main ground which the plaintiff canvassed, which is that this man was incompetent to have executed the relinquishment deed because he was of unsound. That was held in my favor for being unproved. The first appellate court, however, reversed the trial court. That judgment comes on the 26th of February 2013, 10 years thereafter. The first appellate court holds that the suit was time barred. This is a registered relinquishment deed. All of you were residing in the same place. There is no question of you not having known. Your husband was very much alive when you instituted the suit and he was living with you. So factum as to your lack of knowledge is not proved. You have pleaded it, but you have not proved it. To meet the high threshold that is set in the statute, that if you say that you have discovered a fraud subsequent to point of time, you must prove it. The first appellate court also says, when the trial court has already held that he was of sound mind, the burden was on you to show that there was some fraud played which you discovered later. He was of sound mind, then he has executed it. The only question is whether at all he could have executed it in light of the prohibition in the will. Because the will said, which had bequeathed the property to him, that you shall not alienate the property for a period of 10 years. And the first appellate court, applying the judgment of this honorable court of 1981 vintage, says that when a bequest is made, which is absolute in nature, with a condition or cog attached to the bequest, so long as the bequest is absolute, enforce the bequest and ignore the condition. So the first appellate court holds in law that an absolute bequest, when made, this is akin to section 10 of the Transfer of Property Act, when you convey a property with a condition subsequent that you shall not, as the transferee, thereafter do all these things which hit at your ownership, those conditions are void, but the transfer is good. So the first appellate court holds in my favor both on maintainability and merits. And in the course of doing so also says that, look, as the legal heirs of Gurcharan, you are estopped by his actions. You can't institute a suit challenging what the actual owner did under section 115 of the Evidence Act. And various other findings were entered. Matter went up in second appeal. The Honorable High Court framed, as I said, one question, whether the judgment of the first appellate court is liable to interference for being perverse. While framing this question, it noted the contentions canvas, which is only pertaining to the issue on merits, whether the condition can be ignored when attached to a bequest or conveyance. So the second appellate court, unfortunately for good or bad reason, was not in season of the fact that the suit has been dismissed also on the issue of maintainability. The appellants did not press that issue that they had framed in their memorandum of second appeal. They had obviously, because confronted with this adverse finding, framed and proposed such a question The second appellate court, in its wisdom, did not frame it. Eventually, the judgment, which is the first impugned judgment, holds that the first appellate court is wrong in law in its understanding of the will. The restriction is as enforceable as the bequest. There is no difficulty in enforcing both an absolute bequest hedged with a condition restraining sale or relinquishment, and thus restores the decree of the trial court and holds against it. And in review, when I went, I respectfully
We have
submitted
seen-
before the
yeah,
High
we've
Court.
already answered. Okay, now let's have a look at the reasoning given.
Yes,
Both the impugned judgment.
yes.
We have noted the fact.
Lord, if my lords would
Even
straight
today
up
you are
go to
in,
page 6.
you are in partial possession of the flat.
No, my lords ordered status quo. I must apprise my lords of this. So my lords had ordered status quo when the SLP was moved ex parte and said returnable notice on the issue of interim relief. Meanwhile, they had already moved the executing court and taken over the keys. So because status quo was ordered, the shop was kept under lock.
It's a shop or a residential premises?
It's a shop.
It's a shop or a residential premises?
It's a shop.
The shop converted to partially residential place.
At the back portion, because as I said, from 1975, we had permissively permitted them to reside at the back.
Since 75 been residing at the back. Is there a possibility of settlement law?
That is something I am completely open to. According to me, though there are serious legal issues, if I am permitted,
It's a 50-year-old litigation.
No, but I'm not on that.
Yes.
So we are not going to force you.
Yes,
Neither can we force any
your
company.
lordships can refer it, my lord. We can try.
First cousins.
We can.
They are cousins.
First cousins.
Fast cousins, my lord.
And
Now the
what
next
did
Next
did the father leave behind a lot of property? Makhan Singh leave behind a lot of property?
In fact, my lord, that is the grievance. There are two properties. One given to the daughter by way of a registered gift deed. The other given to the son not by way of a registered gift deed or any registered document in form of a sale
But
deed.
by will.
But by will because he is of unsound mind. And one of the condition in that will is that you can't alienate it for a period of 10 years. Now that's the limited aspect your lordships has to test, my lord, that whether that condition is legal or illegal. Otherwise, everything, my lord, there's a concurrent finding by the Honorable High Court and the Trial Court that the will has been validly executed.
They were given what?
My lord, they were given a property in Fateh Nagar. It's situated in Delhi.
What kind of property?
This is a similarly situated property.
Shop.
That's not a suit property also. It's a property. It's a dwelling house
Yani,
in Fateh Nagar. That is also to my understanding of 100 square yards. And this property is also 100 square yards. It was given to the son by way of a will. And one of the condition in that will is that you can't alienate. So that's the finding of the Honorable High Court. That's perhaps because he's of unsound mind.
instructions on this. If the front portion can be given, they can continue.
Counsel for the party state that on instruction state that parties would like to explore possibility of settlement through mediation. In view of the statement made, parties are referred to the Supreme Court mediation. Or should I refer to the Delhi High Court mediation?
Either is fine.
Either is fine, my lord.
I think Delhi High Court might.
As your lordship pleases, my lord.
Because you are practicing in Delhi High Court or there?
Yeah, Delhi High Court.
Delhi High Court Mediation Center, where to explore possibility of settlement. The parties to appear before the mediator nominated by the coordinator of the said center on 18th of March 2025. To stop. Released before the court in the week commencing 5th of May 2025.
My Lord, I am appearing for performer respondent number 6. I may be exempted from in the mediation.
Maybe deleted.
Respondent,
Yeah.
former respondent number 6. Who are you?
I think there were two defendants. One is the daughter.
We have
Other
settled
is
the
the
matter.
person who purchased the other flat which was bequeathed.
But
So
we have
because they're
settled
all
the
common.
matter.
That's not really concerned.
No, I think
We are
it would be
not
better if your
Respondent number 6 need not participate in
Lal Sakti.
I think if it is better if they allow them to be withdrawn from this case because they.
Not doesn't make
Yes,
doesn't make a difference.
we have settled the matter. The matter was compromised and
Okay, fine. That's fine. We leave it.
I mentioned next item, 117. Can the matter be remained on the board?
It will remain on the